Eileen, can you hear me?
Yes, dear.
We're going to take a break for about 15 minutes for the attorneys to review all the documents that have been filed. Judge wanted me to let you know.
Okay, thank you.
Let's see, do we have Mr. Means, or is he still on break here for a moment?
Your Honor, I'm here. I'm sorry. Let me start my video.
Okay.
Let's see. Actually, Your Honor, it's saying I'm unable to start the video. I think I'm going to log out and try to re-log back in if that's okay.
That's fine.
Can you hear me, Your Honor?
I can, Mr. Means, can see you as well. Okay, we'll be back on the record then. Cases CR 2220-755 and 2220-838, State versus Chad Daybell and State versus Lori Vallow. We took a recess for the parties to review and receive these additional pleadings that have been filed in the case. I believe the parties have all had an opportunity to now review the pleadings. Mr. Means, did you receive a copy of the state's motion for testimony of Summer Shiflett?
I did, Your Honor.
And Mr. Pryor, did you receive that as well? You're on mute, Mr. Pryor.
I apologize, Judge. I did receive all of the documents, Your Honor. Thank you.
Okay, thanks. I appreciate you taking a moment for the housekeeping issues. Understanding we've had a lot of things filed here in a compressed time frame. And at this point then, I do want to take that motion up. It was requested to be done on an expedited basis, and as I understand, it may have a relation to the hearing we're determining today, so I think it's appropriate to hear that first. I would note that in addition to the motion, there was an affidavit of Mindy Gee and then a supplemental affidavit of Mindy Gee, which I believe counsel has seen as well. There was also an objection to the affidavits filed by Mr. Pryor on behalf of Mr. Daybell, asserting that they contain hearsay. So Mr. Evans, if you'd like to present argument on your motion for testimony of Summer Shiflett, I'll hear that at this time.
Your Honor, thank you. And it's just argument. Your Honor, as the court, I know the courts probably haven't gotten around to look at our brief, but motions to disqualify are viewed with caution. And when it's not dealing with current or former clients, there's heightened scrutiny that needs to be applied. And I've cited the case for the court on that. Witnesses are the most important aspect of our cases, and that's because they perform the sacred duty of assisting the court to discover what the truth is, and frankly, to assist all of us. This is why before they even speak in court, they need to affirm under oath that they're going to tell the truth. Where we've been the last few days, Your Honor, the defense wants the extreme remedy to remove Mr. Wood from this case. They claim he's been coercive, influence, coached, and this all has to deal with Summer Shiflett and his meeting with her on October 1st of 2020.
Your Honor, if I may, I apologize. I think it has to be said that we're arguing the motion for the testimony of Summer Shiflett. They have cited one rule in their motion, and we are well beyond that one rule. It attempts that they're trying to backdoor in additional arguments for this motion. And having failed to cite this, I don't think that's proper before the court.
I concur with Mr. Means, Your Honor.
Okay, let me address that, counsel. We are obviously still going to have closing arguments on the motions to disqualify the prosecuting attorney. We've got a narrow issue before us on what's styled as a motion for testimony of Summer Shiflett. And in reviewing the motion, Mr. Evans, I will just read directly from it that you've indicated that the motion is made pursuant to Rule 4.2 of the Idaho Rules of Professional Conduct, and you're requesting that this court contact and hear testimony of Summer Shiflett. So I'd just like you to confine your arguments to the narrow issue of whether or not this court should contact and hear testimony of Summer Shiflett, and if so, when would you be requesting that take place?
Your Honor, very good, thank you. Once Ms. Shiflett, so the history on that, after our hearing a couple of days ago, everyone knows Ms. Shiflett called the prosecutor's office.
Judge, I'm going to object at this point. I've filed an objection to Summer Shiflett's affidavit being considered in this particular case. If Mr. Evans would like to cite the case and the case law and the statute that grants the court authority to hear Ms. Shiflett, by all means, go ahead. But if he's going to regurgitate things that have happened that are clearly inadmissible, we're going to have a problem. And I'm going to strongly oppose this, going down this path at this point.
I understand, Mr. Pryor, and I think to correct you, it was the affidavits, not of Summer Shiflett. She hasn't submitted any affidavits.
Mindy Gee, Judge.
Mindy Gee had. And there was a objection made based on hearsay, and I am going to consider that objection and hear and rule on that before we get into what Ms. Gee has to say in her affidavits or what Ms. Shiflett is alleged to have said to Ms. Gee. So I would like to hear, Mr. Evans, there's an objection to those affidavits requesting the court not consider them based on hearsay. And what is your response to the hearsay objection?
Your Honor, it doesn't go to the truth of the matter asserted. Also, she just wants to talk to the court. That's the bottom line.
Who does?
Ms. Shiflett.
Your Honor, I've got to object to the representation of what Mrs. Shiflett has allegedly said to this Mindy Gee, now attempting to come in through Mr. Evans. I mean, we now have multiple levels of hearsay here. And quite honestly, this motion it was identified 10 to 14 days ago. Forgive me, I don't remember the exact date. Mr. Evans, in his own argument, has had plenty of opportunity to attempt to contact Summer Shiflett or even opposing or Mr. Garrett Smith. And it doesn't appear that there were any efforts to do that prior to the hearing 2 days ago. And so again, if we're going to make statements regarding what somebody said to somebody, again, additional problems.
All right.
And Judge, if I could just add that even if Mr. Evans wants to suggest he couldn't go to get a hold of Ms. Shiflett because of Mr. Smith, we have a subpoena process. And I would assume that 2 lawyers from the state would understand that they have every right with 2 weeks notice to subpoena any witnesses that they feel would help their case. Instead, what they did, Judge, is they provided no evidence whatsoever. And at the conclusion, are attempting to do this backdoor tactic, the same kind of backdoor tactic that we had one of the other expert witnesses talk about.
All right.
Bringing,
We're beyond the scope of a hearsay objection as well. So I want everybody to keep in the confined scope of a hearsay objection. Mr. Evans, you indicated it's not being offered for the truth asserted, but you are turning around and then saying, well, here's what someone told Mindy Gee. So I just need to know, do you have a specific exception to the hearsay rule which would allow consideration of these affidavits?
Your Honor, thank you. We're just looking at Rule 803, I think under 1, the present sense impression, so a statement describing or explaining an event or condition made immediately after perceived it, and then as well as the catch-all, the other exceptions, looking at the trustworthiness of it, the factual basis of it, and then the probative point of it. So that's under Idaho Rules of Evidence 803.
All right, I'll allow a response to the argument that there's an exception that applies here under 803.1 and the catch-all. Mr. Means first, and then Mr. Pryor, and counsel, please, again, we're only on an issue here of, do these affidavits contain hearsay? You'll have plenty of time for other argument on the other bigger issues here, but keep it confined to that. Mr. Means, what's your response to the state's indication that there's an exception that would apply?
Thank you, Your Honor. In looking at these affidavits, there's not a lot of difference between the two of them. I think we do have a problem where we have hearsay and then we have double hearsay. And I think the analysis would have to be provided at both levels. I think the present sense impression does not apply, to be quite frank. And trustworthy, I think we have an issue because I don't even think these could be characterized as midnight affidavits, considering this is after the fact of the hearing. This is more of the morning after. So I think trustworthiness is an issue as the prosecution attempts to be coming kind of in a backdoor manner to address what should have been addressed at the hearing 2 days ago.
All right, thank you, Mr. Means. Your response, Mr. Pryor.
Judge, I'll start with the last one, which would be the catch-all, which is usually a tactic used in court to try to get something in when there's no other reasonable reason to get it in. So that's not applicable in this particular case. Trustworthy is not applicable in this case. That's for the court to gauge whether or not a document, and really quite honestly goes to more authentication. The present sense impression, Judge, that's taught in first-year law school. And that's an impression that someone gets upon observing a startling event. And quite honestly, Judge, there's been 14 days for Ms. Shiflett to do this. To suggest that after 14 days we've had a startling event that warrants her to come forward with something is ludicrous. So quite honestly, I can't even by the minimum stretch of my mind imagine any situation where present sense impression would even remotely apply to this. They are grasping. And now I know why they're grasping, because it took a significant amount of time for them to come up with a response while we patiently waited for them to address the hearsay issue. This is hearsay. It doesn't come in. And Judge, again, I guess yesterday I was temperate and I was upset, and I'm still that way. And I want to apologize to the court for that, because I don't mean to be, but this is a very disturbing situation, and to suggest that it's present sense impression is just completely ridiculous. And again, I apologize to the court for my temperament.
All right. I've considered the objection filed. There's an affidavit of Mindy Gee. There's also a supplemental affidavit of Mindy Gee. There's been an objection made that portions of those affidavits contain hearsay. I've reviewed it. The statements of Mindy Gee about what she did in terms of taking a phone call are not hearsay. That's her own testimony in the affidavit. It's sworn. However, these statements as to what Summer Shiflett told Mindy Gee, that Mindy Gee is now telling the court, is clearly hearsay. And so the court will not consider and will strike those portions of both affidavits that pertain to any statements made by anything that Summer Shiflett did say. So that'll be my ruling on those affidavits. All right, with that in mind then, Mr. Evans, would you continue with argument in support of your motion to allow the testimony of Summer Shiflett?
Your Honor, yes, we've found no rule for the court to disallow further evidence in a hearing. This is not a trial. This is just a hearing. There's nothing that says the court has to follow timeframes, especially if the result is a manifest injustice. We believe that the record that the court's trying to rely on is going to be entirely empty of the facts that go to the heart of the issue. And the heart of the issue for the court is, did Mr. Wood's communication with Ms. Shiflett, were those influence, and that led to her changing her testimony to law enforcement. So we believe that her testimony is absolutely crucial. She is the person that we're talking with in all of these matters. and she wants to testify, and we ask the court to allow her to do so.
All right, thank you, Mr. Evans. Response to the motion, if there's an objection, Mr. Means.
Thank you, Your Honor. Again, I think the argument is well off of what the motion that is before the court. The only, if we could even call it a rule that applies, is they cited Idaho Rule Professional Conduct 4.2 entitled Communication with Persons Represented by Counsel. There is nothing express or implied in that rule that allows the court to entertain this motion. There's no attempt to cite any kind of criminal rule or even an implied civil rule that might be duplicated in the criminal rules here. So we're limited again to the argument of, based on the rule 4.2, communication with persons represented by counsel should justify them in bringing this morning after motion. We've been down this road before, Your Honor, when we had a motion for a judicial protective order in a rule and Idaho Rules of Professional Conduct that did not apply. It's the same attempt by counsel here to attempt to do the same thing, which is inapplicable in their request and the remedy in which they're seeking.
All right, thank you, Mr. Means. Your response, if any, Mr. Pryor, please.
Judge, there was a hearing set. I believe Mr. Means disclosed his witnesses and his exhibits. I disclosed my witnesses and my exhibits. Mr. Wood at the time, through his counsel, chose yesterday at a trial not to present any evidence. He made some brief, very brief cross-examination of some of the witnesses, but nothing else. Now, at this point, at the last hour before we make closing argument, this is an attempt to get information in through the back door. And that backdoor process is going to be violative of my client's right to a fair opportunity to present his argument here. Because, Judge, if you allow Summer Shiflett in, I am going to be compelled to ask the court to continue ruling on this motion so that I can bring Mr. Smith back, put him back under oath, and offer rebuttal testimony for Mr. Smith to counter whatever Ms. Shiflett says or to concur with whatever Ms. Shiflett says. And I don't know what Ms. Shiflett says. I haven't heard from Mr. Smith whether Ms. Shiflett even has legal counsel. And if she has legal counsel, Judge, Mr. Smith needs to be present for that examination. And quite honestly, if they're going to be allowed to reopen something that this court closed, and they have cited no rule that allows them to reopen this other than a professional conduct rule, which is totally inapplicable, they shouldn't be allowed to do this. Because if that's where they're going, rebuttal is going to include Mr. Smith again. It's going to include an examination by Dr. Davidson again. It's going to include an examination by Dr. Newton and potentially one other witness that I'm going to call to address that. And quite honestly, this is just an opportunity to somehow backdoor some information in that doesn't go to the root of what the problem is. I think counsel for Mr. Wood misunderstands. The due process argument is only a very small portion of this argument. The reality of the argument is this, Judge. Mr. Wood engaged in conduct that defense counsels both found objectionable. It's not the impact on the witness the conduct that's the question here. The question is whether his conduct itself was egregious enough to have him removed as the prosecutor. It has nothing to do on the influence other than the small portion of due process that'll be addressed later in another motion. The question here is whether Mr. Wood's conduct was egregious enough that it warrants some sort of action by this court. And the example is, Judge, this. Obviously, all of counsel agree that case law on this is very limited and there's not a lot of precedent. But if a prosecutor were to talk to a witness outside of the courtroom and say, oh, by the way, before that witness took the stand, by the way, the defense attorney is a liar and all of these other things that have been alleged well, not alleged, they're on the tape. And then that witness was permitted to take the stand. It would not be the impact on the witness that the court would be evaluating. It would be, what did you say to that witness that potentially influenced you? So that's what the consideration here, Judge, is not what the impact was on Ms. Shiflett. It's what conduct was engaged in that caused the problem that he should not have gone down that road in terms of the way Mr. Wood presented himself and acted for 20 minutes on a tape. So quite honestly, Ms. Shiflett's testimony is really irrelevant to this. It's the conduct of Mr. Wood that's in question here. And I vehemently am opposed to allowing Ms. Shiflett to testify at this point.
All right, thank you for the response, Mr. Pryor. Mr. Evans, rebuttal argument?
Your Honor, just one clarification. If you look on paragraph 10, let me just be clear what the state's wanting to do. So moves this court to allow contact with Ms. Shiflett. The court knows bar counsel was called with this. So the prosecutor's office contact with Ms. Shiflett and or allow her to testify in the court. So Rule 4.2, if you look at the very bottom, that is the state asking to contact her. And so how do we do that when they have been represented by an attorney? You need to get permission from the lawyer, if she still has one, or authorized to do so by the court. So that was done with bar counsel, and that's what the motion is. So it's the state to communicate with her as well as her to communicate with the court. Thank you.
All right, thank you, Mr. Evans.
Your Honor, may I respond to that rebuttal? Because there were some new arguments made there.
Keep it brief, Mr. Means.
I will, Your Honor. When we go through the affidavits of Mindy Gee, given the rulings of this court, the only thing that's admitted that's not stricken as hearsay are paragraphs 1, 2, and 3 of both of the affidavits. Paragraph 4 on the original affidavit would be limited to, on January 7th, 2021 at approximately 2:53, I took a phone call from a female individual. And then the portion after that would be hearsay. Then it says, I stated that he was not available and asked if I could take a message. The rest would be hearsay. Concluding on paragraph 4, the only portion that's not hearsay then says, and I told her I would relay the message. The phone call then ended. The same thing applies to the supplemental affidavit. 1, 2, and 3 should be admitted pursuant to this court ruling. And paragraph 4 is limited to, on January 8, 2021 at approximately 9:30, I answered a phone call from a female individual who, and then the rest is stricken as hearsay. So we don't have affidavits supporting this motion as a result of the court's ruling. There's also additional hearsay from alleged statements of Ms. Shiflett in their motion. In addition, if we look at Rule 4.2, and again, this is just brought up this morning, if you look at comment or paragraph number 6, what they're requesting is beyond what the rule cites. Again, there's no grounds to allow this cited in this rule. If they're asking for permission to speak with Summer Shiflett, I don't think any of us have an objection. The problem is they're attempting to extend the rule or imply what's not in there of give us permission to speak with her and have her testify. That's not part of the rule, Your Honor.
All right, thank you, Mr. Means.
Thank you.
Well, counsel, I've considered this motion in terms of where we are procedurally. Of course, we had a very lengthy hearing 2 days ago on the 6th. We took evidence and testimony during that hearing. We then concluded with the hearing and closed the submission of evidence. This is essentially a request to reopen the submission of evidence, and the request specifically to allow, as the motion reads, for the court to contact and hear the testimony of Summer Shiflett, and then in paragraph 10 to allow her to testify before this court. And that would be based on, again, Ms. Shiflett's request. It says, as Mr. Means pointed out, with the striking of the portions of the affidavits of Mindy Gee that contain hearsay, then the grounds for the motion don't qualify without those statements. And in addition, the motion is brought pursuant to the Idaho Rule of Professional Conduct 4.2, and the court's not aware of the Idaho Rules of Professional Conduct being a proper basis for bringing a motion. At this time, for purposes of the hearing today and our closing arguments, I am going to deny the motion to allow the testimony of Summer Shiflett. So the evidence submission is still closed, although we do have the arguments that have been submitted, which will be considered. So that'll be the court's ruling on the motion. This time then we'll proceed with our closing arguments. Counsel, as I mentioned, we went through and reserved today for these closings. I'd like to take those up at this time now, and I'll just let you know I'm intending to hear your oral arguments. I'm going to take a recess at some point and further review your submitted briefing in addition, but Mr. Pryor, it'd be my intention to have you begin with your closing, then have Mr. Means, and then I'll have the state respond in their closing as well, and then see if there's any rebuttal arguments. So, Mr. Pryor, are you ready to proceed with your closing argument?
I am, Your Honor, if I may.
Go ahead.
Judge, I think there's a misunderstanding by counsel for Mr. Wood. The basis for disqualifying a prosecutor is conduct. It's not the impact that it has on the witness, but rather its conduct. And what I spoke about, Judge, was this in the example I gave just a short time ago. The example is this, is that if you have a witness who's about to take the stand in a jury trial, and either party for that witness approaches them and makes disparaging remarks about defense counsel, makes disparaging remarks about the defendant, and I can't see in any situation where suggesting that someone's a wimpy person or looked like he was about to pee his pants are not disparaging remarks. I can't see where calling Mr. Means incompetent is not a disparaging remark to a material witness. And whether Ms. Shiflett testifies or not for the prosecution is irrelevant. Because if I choose to call her, she becomes relevant. If Mr. Means chooses to call her, she becomes relevant and material. And she's the sister of one of the defendants in this case, who was told, oh, by the way, you know, she won't talk to us, but this is what I'm going to do, and I'm going to charge her with murder. And it would sure be nice when she has competent counsel. Maybe we can get this thing closed up. I can't think of any more direct way that he's trying to circumvent Mr. Means' authority as counsel for Miss Vallow. It's egregious. It is incredibly egregious. Now, Judge, the Idaho Rules of Professional Conduct have adopted the ABA model rules. And the ABA model rules, and Judge, that says it right in the preamble to the Idaho Rules of Professional Conduct. We have adopted the ABA rules from 1969. And under the ABA rules, ethical considerations, Rule 9.4, because the very essence of our legal system is to provide procedures by which matters can be presented in an impartial manner so that they may be decided solely upon the merits. Any statement or suggestion by a lawyer that he can or attempt to circumvent those procedures is detrimental to the legal system and tends to undermine the public confidence. Now, that's from the ABA rules, Judge, which have been, for all practical purposes, adopted in our Idaho Rules of Professional Conduct.
Mr. Pryor, I do want to make a correction there, because the Idaho Rules of Professional Conduct are, as it states in the preamble, largely based on the ABA model rules with some Idaho variations.
That is correct.
I would ask that if I'm following along here, if you're citing to any specific rule of professional conduct, please cite to the Idaho rule, because they are largely the same, but if there's a difference, we need to rely on the Idaho precedent. So,
and I understand that, Judge, and what I'm trying to do is I'm trying to say, in the spirit of adopting the Idaho Rules of Professional Conduct, they considered the ABA rules. And it still goes to the same essence, Judge, which is this. Our Idaho Rules of Professional Conduct require that we do everything we can as lawyers to engage in an impartial system that does not allow undue influence from any party or their attorneys to jeopardize the opportunity for a defendant to have a fair and impartial trial. I cannot think of any situation that is more egregious than a prosecuting attorney who would go in and interview a witness and for 20 minutes not interview the witness, but rather offer a monologue of what his theory is in the case, disparage counsel, disparage the defendant, and manipulate. Now, I want to point out that the prosecutor in this case presented no evidence in rebuttal to counter Dr. Davidson, to counter Dr. Newton, and to counter Attorney Garrett Smith. They offered nothing. And to suggest this high scrutiny by Mr. Wood's attorney is completely inaccurate. The question is whether or not an attorney and a prosecutor who's required to live by a higher set of rules has engaged in conduct that jeopardizes Mr. Daybell and Ms. Vallo's right to a fair trial. Now, the purpose of Dr. Davidson, Judge, is this. I did not want to, and I can't speak for Mr. Means, but I didn't want to subject Summer Shiflett to all of these people out there watching this and put her on the spot. Dr. Davidson got on there and he testified that it's, without credulity, that there was not influence here. He's suggesting, listen, there's no way there wasn't influence here. And he specifically put a report that has been admitted and detailed every single line of where Mr. Means engaged in completely inappropriate conduct. Now, I read the brief from opposing counsel and they said, well, this isn't what was going on, but Mr. Wood's affidavit in the original objection to this, Mr. Wood specifically said in his statement, I did not coach, influence, or intimidate any of these witnesses. Well, I beg to differ, Judge. Dr. Davidson, in no uncertain terms, stated implicitly that these statements clearly were influential in a attempt to influence Ms. Shiflett, without a doubt. Dr. Newton, when we talked about the process here and what was transpired, what did he say at the conclusion of the hearing? Well, the reason we don't have these sort of things is because it's unusual for these matters to occur other than in front of a jury. But when they occur in front of a witness, it's a rare situation. And you want to believe a prosecuting attorney. You want to believe someone who is supposed to be righteous and uphold justice and do it the proper way. And the tendency with courts is to say, listen, unless you have some proof that the prosecutor has engaged in some conduct that is detrimental to the administration of justice, I think it's appropriate because his job generally is to uphold justice. But what did Dr. Newton, the expert on case law, the expert on authority, what did he say that was compelling? He said, he, meaning Mr. Wood, got caught. Now, getting caught is not the term you use unless either you're fishing or you're lying or you're cheating. And Mr. Woods is cheating, Mr. Wood is lying, and Mr. Wood is doing nothing but trying to influence, coach, intimidate a witness before that witness has had a chance to get in front of a trial. My concern is this, Judge. I don't have any other recordings other than Zuluma Pastenes. And I'll be going through that, and we may be revisiting some issues once I've had a chance to go through that in the final interview with Ms. Pastenes. But I don't have any other tape recordings. But what I do have is an interesting thing that occurred. And I know this court wasn't part and parcel of the preliminary hearing back in August of this year. But I had an opportunity during that preliminary hearing to talk with Ms. Gibbs while she was on the stand. And I was questioning her about what she knew, what the prosecutor had said to her. And after I asked her what the prosecutor had said to her, Judge, she immediately turned on the camera and looked directly in Mr. Means's eyes. And I said right after that, why were you looking at Mr. Means?
Your Honor, I'm going to object for hearsay.
This is argument, Judge. This is argument. This isn't the presentation of evidence.
I understand, but you're still referencing a specific comment someone made out of in a separate proceeding. I think that's hearsay.
Okay. Well, Judge, my concern is this, is that having to bring up the subject of whether Ms. Gibbs was looking at Mr. Wood when I said that, and the fact that I brought it up, and the fact is, Judge, I observed Ms. Gibbs look in the eyes of Mr. Wood when I'm questioning about what sort of conversations they had. That causes me great concern. And everybody in the world can look at it on YouTube and see that there was concern. So what assurance is the court going to be able to give me that these meet and greets that Mr. Wood has engaged in, these 20-minute monologues, have not occurred with every other witness in this case? Because if the court cannot give me assurance, you're going to require me to go to every witness with an investigator, interview them, and question them in detail about what Mr. Wood has talked to them about and whether this meet and greet tactic that is completely unprofessional, that is completely unethical, that is completely wrong was conducted on other witnesses in this case. And if that can't be questioned to a certainty and assured that there hasn't been influence with other witnesses, how am I going to be sure that there's going to be a fair trial for Mr. Daybell? Because you can't. And there is only one thing this court can do. We need to remove Mr. Wood, and then there'll be additional requests regarding the witnesses further down the line in terms to how we try to cure this atrocity. Judge, there are a number of problems that I have in terms of the Idaho Rules of Professional Conduct. And in terms of the Idaho Rules of Professional Conduct, Judge, we do have Rule 4.2. And Judge, it is misconduct if you violate any of the Idaho Rules of Professional Conduct. And at this point, under 4.2, you are not allowed to encourage or in any way try to contact someone who has legal counsel. I cannot see how Mr. Wood's statements leading Summer Shiflett through this process of, oh, it's going to be murder charges, and it would sure be nice if we could communicate with Miss Vallow about this. And as Dr. Davidson implied, it seemed to be, and Dr. Newton implied, it seemed to be a back way for Mr. Wood to try to get Ms. Vallow to speak. Now that's clearly a violation if you're trying, even secretly or indirectly, to try to communicate with a witness or with a defendant who has legal counsel. That is a big problem. In addition, he violated the preamble. He is not doing this. There is no way anyone can suggest that his comments did not influence or attempt to influence a witness in a case. That's not justice. 3.8, the prosecutor's obligations. He violated his obligation as a prosecutor to try to present an impartial hearing, and his heightened obligation to do everything that he could to be fair and afford the opportunity for a defendant to have a fair trial is a violation, another violation. And Judge, I can spend hours going through and point out a number of these. Now, obviously, I've been verbose, and I've been verbose in the past, and the court has been very patient with me. But if the court looks at the transcript of the proceedings by Dr. Davidson, if the court reviews Dr. Davidson's report, he makes an emphatic representation that this was influence. Now, Dr. Newton was not going to circumvent the court's authority to make that decision. Dr. Newton was not going to override the court's power and say, oh yeah, this is prosecutorial misconduct. He said that it was up to the court to make that decision. It's up to the court to decide whether this is enough for there to be a disqualification of Mr. Wood. But what he did say, which was interesting to me, Judge, is this. He said, Mr. Wood's behavior was a learning moment, and he meant for his future students at law school. It is a learning moment on what not to do. On what not to do. That would suggest to me that it's a clear ethics violation. What else would suggest to me from Dr. Newton that it was a clear ethics violation is that he would get caught and that he got caught. And again, as I stated before, when someone says you got caught, either you're fishing or you're breaking the law or you're a cheater or you're a liar. I'll pick which adjective because I don't think Mr. Wood was fishing. Now, Garrett Smith in one of his closing arguments at the end or his testimony stated, I can't see any possibility other than that it was influencing or attempting to influence Summer Shiflett, and there is no reason for why Mr. Wood did this. Judge, the totality of the circumstances are this. We have one of the biggest trials in the state of Idaho, and people are watching this with attention that I can't even fathom. We are all under the gun and we are all being watched very carefully. And any first-year attorney who's going through law school is entrusted by ethics and taught about ethics, that these are the things you do not do. And Mr. Wood has been practicing for a while. He has told me before that I did plenty of defense work. I'm a prosecutor now. And Judge, for the record, he also told me on 2 separate occasions.
Your Honor, objection for hearsay.
Sustained.
Judge, I can't think of a reason why Mr. Wood would need to go out and interview Summer Shiflett. Mr. Wood took it upon himself to go out to Arizona to interview a witness. He knew before he was leaving that he was going to engage in this meet and greet and do this. Because if he didn't know that he was doing it, then he doesn't understand the rules of ethics. He can't say, oh, I didn't know what I was doing. He knew darn well what he was doing. And the only problem and the only complaint is this, Judge. He got caught. In the infamous words of Dr. Newton, he got caught. And to suggest by distracting, saying, well, Ms. Shiflett will say something else. Or, Judge, the impact on the witness. That's not the standard. It's the conduct. The standard is, was your conduct so bad that it had an impact on the trial in this case? I can't think of a more egregious situation other than a prosecuting attorney in one of the most high-profile cases in the state of Idaho, and I could argue, Judge, in the United States. I don't know how many people are watching me right now or watching us right now, but I would imagine it's significant. And this prosecutor, with full knowledge and at the expense of Fremont County, chose to fly out to interview a witness and suggesting that it was going to be a meet and greet, and then spends 20 minutes of a narrative doing everything he can to influence this witness to testify a certain way. And it's not whether the witness was influenced. It's the fact that he did it. And who else did he do it to? What other witnesses in this case did he do? Because we'll never know. We will never know the extent of what this prosecutor has committed in this particular case. And I can't think of any better reason to disqualify him than the fact that we don't know what else he has done. And quite honestly, Judge, anything he says about what he has or has not done, I have very little faith in anything Mr. Wood will say. And at this point, I will defer to counsel.
All right, thank you, Mr. Pryor. Mr. Means, your final argument.
Thank you, Your Honor, and obviously I concur with Mr. Pryor on his points made. Does the court want me to go ahead and attempt to argue some of the points made by the state's brief that was filed this morning as well in the closing, or do you want to save that for rebuttal, Your Honor?
I'll leave that up to you, Mr. Means. If you want to address the points in their brief, at some